Okay, good afternoon, everybody. Thanks for coming. My name is Jamie Leader. I'm a partner in the Commercial and Business Litigation Group here at V&E.
Yeah, thank you for joining us for this Navigating Series presentation. Today, we are talking about how to navigate post-closing disputes in the private M&A space. You've spent months negotiating your transaction. You have hired a first-class deal team, hopefully from Vincent & Elkins, who has implemented your negotiation with precision. Deal makes sense for both sides. What could possibly go wrong? Experience suggests a lot can go wrong. And we're going to talk a little bit about some of the common causes for post-closing disputes. And then we're going to point out some structural things you can do to minimize the occurrence of these disputes, and then also some tools for minimizing the pain and disruption of how you get through them if they inevitably arise. My name's Chris Popoff. I'm a trial lawyer in Houston. I'm the head of the Complex Commercial Litigation Group at V&E.
And as you know, I'm Jamie Leader. I'm also a partner in the Complex Commercial Litigation Group in V&E. So real quick, running through the agenda, we've kind of grouped our observations here into three things we wanted to talk to you about. And I'll say the idea is for this to be the first time we talk to you about this topic, but probably not the last. And so I wouldn't think of this as a comprehensive run through all things. It's sort of the things we've run into in handling these disputes over the last few years. So we're going to talk about unanticipated process, which is probably easiest to define as the opposite of anticipated process, which is something that you've negotiated to figure out later. We're going to have an earn-out. We're going to have a purchase price adjustment. Unanticipated would be something that's come up. Maybe it's a rep and warranty claim. And then we'll close talking about drag-along rights, an area that is in a lot of the contracts and transactions we see, especially in the private equity space, but that isn't litigated with much frequency, although we have some experience there we want to impart. But before we jump in too much to the types of disputes and how to handle them, we want to step back a little bit and talk about what drives these disputes. And I think that the litigators love lists of three, so you're going to get lots of lists of three from us. We think about this as three different drivers for these disputes. And the first one I'll elegantly call oops disputes. And the best example of an oops dispute I could think of, the lawyers may remember in law school, this famous case where poor guy in London buys all of the cotton on the Peerless ship sailing from Bombay to London. Unfortunately, there are two Peerless ships sailing from Bombay to London, and the price of cotton fluctuates wildly between the two ships arriving in London. So the fight is about which Peerless we're talking about in the contract. That's an oops, because the lawyers back then should have negotiated and had more specific language in the contract about what ship we're talking about. So there, as you see in my AI-generated image for this case, the guy with the iPad is fighting with the other guy about what ship we're talking about. By and large, the disputes that we are talking to you about today are not oops disputes. And I'm not just saying that because we have transactional lawyers watching and our general counsel's office wouldn't like it. It's really, parties have sophisticated counsel for these things. You're spending a lot of time negotiating it. You don't frequently end up with some crazy ambiguity in the contract that we didn't think of, but we now have to sort through. That's not to say that there aren't fights about what the contract means. There certainly are, but I don't think that's really the issue that's driving the dispute.
The bigger thing that we see really falls into categories 2 and 3 on the slide. The first is delayed negotiation. And so what we're talking about here is the structure of a deal that puts off the finality to some term until post-closing. So this is like the purchase price adjustment, the earn-out provision, heaven forbid, or like a holdback in an escrow. The parties there are saying, look, we haven't really finally settled on price, and there's some things that are going to happen post-closing. They're going to really button up risk allocation or price. That's delayed negotiation. When we see those kind of provisions, litigators think, well, the parties never really agreed on price. What they agreed is to litigate later and figure out how much the deal is going to actually be about. Very different dynamic, because unlike negotiating pre-closing, you don't have the hammer of just backing away from the table and walking away. Now, if there's going to be resolution, it's probably going to be through force of law. And then the last example here is surprise. And this is when there's some fact that's discovered after closing. For example, the accounting treatment of some asset was poorly handled, or a critical customer agreement goes away, or a patent that was anticipated isn't issued. The contract may very well cover those issues, but when you're dealing with some sort of fundamental disagreement about the state of the world that both parties had going into the deal, we see post-closing disputes around those issues. So again, we're assuming you've got a good contract, but something has happened post-closing, either by structure or by unanticipated mistake that leads to the dispute. You hear bad facts make bad law. In this world, we think bad facts sometimes lead to bad contract interpretation arguments, and that's where we're going to spend most of our time today.
Okay, so let's start with the unanticipated post-closing disputes. And one observation that might be a surprise to some in the room is that our view is that these kinds of disputes come up with some frequency in the world that we're in. And, you know, Chris and I will get a dozen calls a month on some post-closing dispute between the two of us. Other partners, lawyers in the firm are getting them too. And then I assume for every one I hear about, there are a few that just get handled either by the client or by the transactional lawyers. They work it out and then the problem goes away. The vast majority of these don't end up in some sort of formal litigation, but it does come up somewhat frequently. The other observation I would make about these is that very often the one side in the dispute, not our side, of course, is making what I think of as a terrible argument. They're bringing a claim that doesn't really make sense on the paper, and the deal lawyer will call me and say, this is obviously not how things are supposed to work. Nobody does this, but this is the argument they're making. You don't see as much of that in commercial litigation outside of this context. And I think that's because in a lawsuit that I'm in outside of this context, you know, I think we're going to win. I like our case, but I can understand why it's a dispute. I can understand what the parties are fighting about. Often we will get these kinds of claims and the other side's position seems like such a loser. Why would they possibly bring it? And I think there's a few explanations for that. One can just be emotion or somebody who's trying to improve a bad deal and it's sort of desperate. You know, maybe Chris talked about surprise. Maybe the surprise is just that the economy has changed in a way that makes this a bad deal for the buyer. Maybe a bunch of key employees have left unexpectedly. Maybe some synergy they thought they were going to get hasn't been achieved. And so bringing a claim like this can be a way to try to salvage sort of a win out of the back end of a transaction that's not looking so good. You also have information asymmetries, this sort of weird scenario where prior to the closing, the party with all the information is the seller, and then after the closing, it's the buyer. And so both parties are sort of looking at half the picture. And you can imagine how that creates conflict or misunderstanding because we're sort of telling different stories. And then another issue is that's sort of related is like some mistrust or some acrimony. You know, maybe these transactions get heated, the sides don't like each other, and it closes. That creates a different dispute dynamic than, say, for example, you've got some vendor for 20 years that you've been working with. There's trust, there's understanding there. An issue comes up, you can pick up the phone and work it out. These parties may never have spoken directly on the phone without lawyers, and they don't have a relationship to fall back on. And then lastly, and I think the biggest one, is very often in these scenarios, somebody's holding on to money that the other side wants. You know, the buyer will have some holdback, or there'll be some escrow release instruction that has to go out. And they say, well, I'm not going to release the money because I have this claim. That's a fundamentally different dynamic than regular litigation, because in litigation, you've got to sue somebody else to get money out of them, right? Typically. Here, you would say, I'm going to hold back this $1 million holdback on this claim I have. And if you think it's a bad claim, sue me. But I'm going to negotiate with you for a while and try to work that out. So I think that can drive the frequency of these disputes as well. And then another one just that we kind of have to talk about because it comes up is there is a perception in the market that private equity firms especially don't like to litigate, and that if you threaten litigation, they will work out some commercial resolution to avoid litigation. And I don't know if it tracks exactly all the reasons that ChatGPT has put forward here, but I asked and that's the answer I got. So that is a perception that's out there, and it's a dynamic you have to keep in mind. A seller might think, I can get a little more money out of this deal because the private equity buyer won't want to litigate with me, or vice versa.
So the takeaway here is it is nice to have clear reps and warranties. It is nice to have precise deal terms, but it is better to have leverage. It's better to structure the deal in a way in which the status quo is a strength for your side, and the other side is in a position of having to spend time, money, and energy to try to change the status quo. If you could have that over a precise or gotcha representation, I think you take the structure and the status quo any day. So with that understanding in mind, you thought about structure, but there's an inevitable dispute. How do we think about navigating these claims? So we're going to hit three things. Number one is, how do you bring the claims? And so this is the classic dispute resolution clause. Are you in litigation? Are you in arbitration? Which forum are you in? Two, what claims can you bring? What are the kinds of claims? What is the subject matter that is within the realm of things that can be litigated post-closing? That can be limited by subject matter. That can be limited by amount and controversy, whether high or low, floor and ceiling. And it can be limited by temporal limitations, all sorts of ways to sort of cabin risk and focus what the post-closing dispute could be. And then finally, there are practical considerations. These are inevitably disputes involve human beings. What is the dynamic of those human beings post-closing? Who has the money? What's happening in the market? What are the relationships like? What are the incentives? And we're going to talk about how all of those things influence the decision-making in a post-closing dispute. So first, how do you bring claims? Where do you bring claims? You can do an entire CLE on litigation versus arbitration. People ask us, does V&E have a litigation position on which is better? It's a punt, no. I mean, I think the answer, like many things in law, is it depends on lots of factors. It depends on what you want. It depends on where you are. It depends on who your counterparty is. The one thing I would say is, while there is not a right answer, I would say the wrong answer is to default to a boilerplate position and assume that the same dispute resolution clause ought to apply in every case. We think the right way to think about how you bring claims is through sort of an issue-by-issue analysis. You ask yourself, how would these following factors influence whether I would bring a claim if I thought I had a 50-50 chance? For example, do you care if your competitors or customers know that you're in post-closing litigation? Is that something that matters to you? Maybe you want the world to know because you think it's a leverage point that your counterparty will be embarrassed of. Maybe it's something that you desperately don't want people to know about. So the public versus the private nature of the dispute is a very important consideration, and that's a fundamental difference between state court litigation and arbitration. What is your need for discovery? How do you feel about your executives, your employees being deposed? Are you going to need discovery from a third party who's not part of the deal? That's going to have a great effect on the kind of dispute resolution clause you have or you want to have. Do you need a fact finder with industry expertise? Is it the kind of post-closing dispute that really requires a niche understanding of the market or of the technology? Or do you really need someone who's got a heavy stick, who can deal with a dishonest or obstinate opponent using the force of law, the way a judge might be able to do on a better basis? So again, there's not right or wrong answers to any of this, but they're all considerations that do impact what is the right dispute resolution clause for your case. I also just sort of abhor sort of like blanket statements about how one process works versus the other. We hear arbitration is just as slow as litigation. It's more expensive than litigation. Arbitrators split the baby. This is like the only thing I've been doing for over 20 years. That is not my experience. A lot of times anecdotes fuel people's positions on these kinds of things. So I think, the bottom line here is this is a question that is worthy of discussion, and there are a lot of factors that go into where you would want a post-closing dispute to be brought.
And there are also, just like there isn't a one-size-fits-all answer across contracts, there may not be a one-size-fits-all answer within a contract. You might want an expedited arbitration procedure for certain types of disputes in a transaction. And this is just an example on the slide, but say you're in a situation where you really are going to care about rep and warranty disputes that are smaller than 5 million, but maybe say they're bigger than 500,000. You could work out a procedure, and you can agree to all of this, and it's not particularly complicated, that would enable you to get to an answer in 100 days with a somewhat minimal spend. And, on the other hand, that would encourage people to bring claims, but you could impose an attorney's fees provision so that the prevailing party gets their fees covered, which should discourage the sort of unmeritorious claims. So that's something you could think about, and you can work into a contract for certain categories of disputes or certain size of disputes. you don't have to have the same 2-year arbitration process, no matter how big the dispute is.
The takeaway here is just avoid a one-size-fits-all approach to your dispute resolution provisions. We see the same kind of thing get cut and pasted into, various agreements. Sometimes that default provision is a good one, but there are a lot of circumstances where it might not be. This is something that it's worth talking to somebody with some litigation experience who can help you think through what the risks are and what the levers are going to be for your side if a dispute does arise.
And then now we're moving on to what kinds of claims you can bring. And some of this is pretty deal and industry and context specific, so it's hard to make kind of global statements. But one thing we've run into is an increased reliance in contracts on what I'll call capital F fraud as being the governing standard for when you can bring a fraud claim. So the Supreme Court of Texas lists out the elements of fraud, and it includes either proving that the speaker knew the statement was false or that the speaker made the statement recklessly without any knowledge of the truth. Capital F fraud, as we frequently see it, will exclude claims based on constructive knowledge or recklessness. So what this means is if you're going to prove fraud, you've got to prove that the sellers, however that's defined, maybe that's 5 individuals, maybe that's 1 individual, it's usually not an entire company, knew something was false when they represented it to you. And just think about the factual burden that puts on you in a case. Maybe you find a hot document that solves the problem, but more likely than not, you're going to be in a scenario where you're saying, come on, how did they not know this? But it's hard to prove actual knowledge. And so if you're in a contract where this term is there, if you're the seller, you probably love it. If you're the buyer, I think you want to be conscious of what does fraud mean for me in the transaction? Is there a really low cap on the amount I can recover for a breach of a rep or warranty absent fraud? And if that's true, you're really going to be kind of holding the bag if you've been if there's some major breach that you think is fraud, you're practically going to have a really hard time proving it. I was in a mediation last year where this issue came up, and the other side's position was essentially not, you guys are wrong, there wasn't a breach. Their position was, you're not going to be able to prove actual knowledge for fraud. Nobody can prove actual knowledge, so you should settle because it's going to be too hard to prove it. And, we were able to get a recovery there, which I think our rep and warranty folks say is unusual in a fraud context. But our mediator was basically like, yeah, they're right. Nobody proves actual fraud. Now, obviously, sometimes you can, but it's something to look at when you're entering into these provisions. And this is an example of how that works that I'll hit in a minute when we talk about rep and warranty insurance.
Okay, so just sticking on this point of the unanticipated claims, we're going to talk later about the anticipated claims that we hit at the outset, the working capital adjustment, the indemnity holdback. But what are the kinds of claims that we see as the most common of the unanticipated claims? A few high frequency points are non-compete and competition area agreements. Those are ripe for dispute. Best efforts clauses are, anybody who's committing to use best efforts to accomplish something is really not committing to do anything. It's very, very hard to prove that somebody didn't use their best efforts. It's kind of the flip side of the fraud point of view, and the case law is very favorable to the actor in that circumstance, and so it can lead to frustration and dispute. Complicated tax scenarios that really implicate the value of the acquisition. So in the world of transfer pricing, for example, the way the seller ran the company might affect the way the buyer accounts for it on the back end, and that can really change deal economics. In the energy transition space, we see tax equity disputes because that's such an important driver of the value of what's being bought. Our oil and gas experts really harp on the importance of title representations, deals that involve large producing areas and that have been under production for decades. There'll be broad representations about the cleanness of title, which is a very difficult, sort of piece by piece inquiry that can lead to disputes. So these are some sort of hot button areas where we would say, while we're talking about the world of the unanticipated, these are the ones that we see coming up frequently. So if these are important provisions in your agreement, be careful around diligence on these points and think carefully about how you want to word them, because in our experience, they lead to a lot of post-closing disputes.
And the flag at the bottom there is ongoing litigation and privilege issues. That's an area we get consulted about a lot on the front end. You know, there's a deal and here's this big litigation that's happening and we've got to structure how the indemnities work and how the cooperation works. I have not personally seen a dispute that comes up about that. And I think that's because the incentives are a little different post-closing to sort of cooperate in this area. But it's an important thing to think about, just like these other ones, because you want to have sort of a rational approach to litigation that you're inheriting or that you're maybe having an indemnity obligation for, but doesn't necessarily lead to disputes in my experience. And then here are practical considerations. I flew through the example real quick, but the founder of the company being sold was on the other one, and this is AI's version of the founder after he sells his company. So, you know, think about where your sellers are going. Are they retiring to a beach where they have nothing else to do? That might suggest they're going to fight you more on post-closing things that come up because they got nothing else going on. Are some of your sellers remaining with the company you're buying as key employees? Think about the fraud example where you have to prove that the sellers knew something was false. Those sellers could include your current CFO. And, you know, how does that go? What does that dispute look like? And you want to structure a process that ideally protects you from blowing up your own operations to sort of vindicate your rights under your reps and warranties. Obviously, they could also be going to a competitor, and you'd want to think there very carefully about how you get information about compliance with non-competes and things like that. And then as Chris has already flagged, I think the major thing people sleep on is the sort of practical reality of whoever holds the money having significant power, because you don't really want to run into court and sue somebody for not releasing an escrow. And so obviously there are good reasons to do a holdback, to do an escrow release. I'm not saying never agree to it or anything like that, but think through the practicalities of how you're going to vindicate a claim and get that money out if there's a dispute. And I want to talk a little bit about reps and warranties insurance. This is an area that I think there is a separate CLE on this given by the people who do it all the time. When I talk about rep and warranty insurance lawyers at B&E, the structure is essentially there's one main partner, Sarah Mitchell, who is in the M&A group, and she will work with you in doing a transaction, getting rep and warranty insurance. She's also involved on the back end if a dispute comes up, and then some of our litigators come in and help her with that, myself, Chris, others. You'll see a slide at the end, but that's kind of the process on our end. For those who aren't familiar, this is an increasingly common thing in these contracts where the buyer will obtain a policy for breaches of reps and warranties. The parties negotiate how that policy gets paid out and paid for. And in return, the buyer waives most post-closing claims against the seller, except for fraud. So I can only recover on my $10 million rep and warranty policy for breaches of reps unless there's fraud, and then I can go after the seller. And then usually there's some sort of deductible and the parties negotiate how the deductible gets satisfied. Once you have a claim, you go to the rep and warranty insurer, just like other insurance claims you bring, and that starts a process. A couple other things I want to say about this before I talk through an example. Our rep and warranty insurance lawyers have handled the payout of over $120 million in rep and warranty claims over the last few years. The largest examples are for private equity clients, but it's across sort of client types and industries. These have come up in financial statement problems, labor issues, compliance with law and insurance obligations, key customer disputes that come up. I mean, really, if you can think about a rep that might be breached, we've seen an example of that. And I'll explain in a minute why that's so important when you're fighting out these disputes. Another structural thing I'll flag here is that the time period for this policy can often be longer than the rep and warranty covenant period in the contract. So you might get a little more protection from the insurer than you have from your seller under the contract. So what is getting a rep and warranty insurance claim paid out like? It's a lot like getting a regular insurance claim paid out. This is an image of a rental, or supposedly an image of a car I rented in North Carolina last month. And I returned the car and I got an email from Hertz that I had scratched the passenger side door with that little box there. You can maybe see it. There was no accident. I don't remember anything sounding scratched or any issues coming up, but I have rental insurance through my credit card company. Great, I will submit a claim. That list on the right are all the things they've asked me for. I haven't actually submitted the claim yet because I don't have a police report because there was no car accident. And so I'm trying to work that out. If you see my wife, I didn't tell her about this, so don't mention it. But it's a huge pain. I think eventually we'll get there, but it'll take a lot of time and effort. That's kind of how rep and warranty claims go. Our rep and warranty lawyers call it litigation light. So you're not sitting for a deposition, you're not cross-examining someone or being cross-examined, but you're in a somewhat adversarial position as you work through getting this claim paid out from the insurer. It's really important that you're on it early, that you're talking internally and with counsel about what you think happened, and you're protecting privilege there. And then you go to the rep and warranty insurer with one voice and one story about what you think the problem is. I know I sound like a billboard on the freeway here, but do not settle in these contexts before you consult with a lawyer and a litigator who can sort of walk through the claim with you.
You've got a good billboard last name too. You could...
Yeah, I could slap my face on the do not settle billboard. Okay, so here's a quick example of how this plays out. And this also ties in with the capital F fraud definition I gave you. Now, this is, again, I figured out how to do this like 2 weeks ago, so maybe I got overly excited. But here's my AI-generated company founder, and he's selling his company, Clean Truck LLC. I asked ChatGPT to make up a private equity firm name, and they came up with Meridian Forge Capital, which I kind of like, and that's the logo. So Meridian Forge buys Clean Truck. They come in and they realize that many of Clean Truck's engineers don't have legal status to work in the U.S. This is a major problem for Meridian Forge. They go to their rep and warranty insurer and they say, there's a covenant that says our employees have legal status. That's been breached. Now we've got to fire all of them. We've got to hire new employees and we have to shut down production for 4 months while we do this. It's going to cost us $15 million. Say the rep and warranty policy is $10 million. Meridian Forge at this point is thinking, okay, I'm going to sue the seller for capital F fraud. And as we talked about before, seller is going to say, good luck proving that I knew that all these employees were not legal. But let's leave that to the side for a minute. Meridian Forge doesn't want to litigate this publicly. They don't want the market to know that they had all these illegal to work employees that they've had to fire. So their incentive is to get this rep and warranty claim done as fast as they can so they can move on with their business and use the cash to invest in replacing that workforce. The insurer's incentive is to do two things. One, get all those documents we talked about, take plenty of time to look at them, figure out what's going on, really scrub Meridian Forge's damages model here. Are you really going to be out of production for 4 months? Maybe it's 2 months. And the other problem is the insurer might want to sue the founder for fraud because under the policy, the fraud claim gets subrogated to the insurer. So you're in this weird position if you're Meridian Forge of trying to convince the insurer maybe, no, there's no fraud claim here. Just go ahead and pay out the claim to me and release the sellers. But privately you're thinking, well, maybe I want to sue the seller for fraud. So you're doing this weird dance where incentives are different. And it's just an example of how you have to be really careful when you're pitching your claim to the insurer and when you're moving forward, that you're doing something sort of consistent with your broader business goals. And if your goal is to maximize money, you sue everybody, you allege fraud, and you see where the chips fall. If instead your priority is short-term cash, you want to make this a clean rep and warranty claim that you work through with the broker. The last thing I'll say on this is that you'll have an insurance broker who will get the policy for you and who you'll call when this comes up. The dynamic here is the brokers push the carriers to give you good service, but they're repeat players. They see these people all the time. So their incentive to be really forceful and yell at them because they're being too slow is kind of low. So the way you get leverage here is you hire lawyers who do a lot of rep and warranty deals because then the broker and the carrier want those lawyers to be happy with them and to have a good customer experience. So it's an example of how doing all these rep and warranty claims in our deals, doing them in litigation, it sort of feeds itself. And you want sort of institutional experience with these brokers for when a claim comes up.
Okay, so that we're going to transition from the unanticipated post-closing process claims to the anticipated post-closing process claims, which is where we see a higher volume of disputes, and that's probably for obvious reasons because the deal was structured in a way that sort of encouraged the parties to go down this litigation route to really finalize the terms of the deal. And so what we're talking about here are purchase price adjustment provisions, working capital adjustment provisions, and earnouts, indemnity holdbacks, escrows, all that kind of stuff that deals with value exchange post-closing. This, I'm sure, looks a little elementary, but I think it's useful to kind of put to words how the negotiating dynamics change so fundamentally pre and post closing. So pre-closing, obviously, are you going to do a deal? The question is, are you getting value? Does it outweigh the concessions that you're giving? That's the consideration. And then you're always weighing that against your next best option. So the leverage that you have in this situation is to slide back away from the table, withdraw from the deal. It's this.
Yeah, so I can't do a presentation like this without video clips. Very restrained too in this one. This is from the movie Heat, where Robert De Niro and Al Pacino, somewhat implausibly, Pacino's a cop, De Niro's a crook, and they sit down at the table and have this nice conversation about the philosophy of crime and police work. In this clip, De Niro is explaining to Pacino sort of how he lives his life so as to be able to evade the police. I promise I'll tie this back to the presentation afterward.
Guy told me one time, don't let yourself get attached to anything you are not willing to walk out on in 30 seconds flat if you feel the heat around the corner. Now, if you're on me and you got to move when I move, how do you expect to keep a marriage?
Well, that's an interesting point. What are you, a monk?
I have a woman.
What do you tell her?
I tell her I'm a salesman.
So then if you spot me coming around that corner, you're just gonna walk out on this woman? Not say goodbye?
That's the discipline.
Okay, so in this analogy, you, the deal maker, are Robert De Niro. You're tough. You are ready to walk away from the deal in 30 seconds if you don't feel like you're getting good terms. And Robert De Niro's, we'll say, partner in this scenario is the deal that he's walking away from. You want to be De Niro. You have the freedom to leave when you can. But
Yeah, and the idea obviously is that things change. Like post-closing, you don't have the luxury of walking away from the deal the way De Niro's doing in his tough talk. If you're trying to get something you want post-closing out of the deal, you can't back away from the table. There's no sort of threat of the deal going away. Now, the levers you have to pull are using the force of law. And that looks like litigating, or that looks like using the leverage of litigation to try to compel an outcome that the other side doesn't want to give. And that is, the whole point of this, inevitably expensive and disruptive.
And so this clip here, and I feel like a Peloton instructor saying this, but we have some salty language in this one. So if you need to go on headphones for people in the room, you can. Here, this is from The Big Lebowski. You have the dude and Walter. Their friend Donnie has tragically passed away, and they're at the mortuary to pick up his remains, where he's been cremated, and they're working on how to get him from the mortuary.
Hello, gentlemen. You are the bereaved.
Yeah, man.
Francis Donnelly, pleased to meet you.
Jeff Lebowski.
Alter subject.
The dude actually is,
Excuse me?
oh, no.
Yes. I understand you're taking away the remains.
Yeah.
We have the urn. I assume this is credit card.
Yeah. What's this?
Now that's for the urn.
Don't need it. We're scattering the ashes.
Yes, so we were informed. However, we must, of course, transmit the remains to you in a receptacle.
This is $180.
It is our most modestly priced receptacle.
Well, can we just,
$180?
They range up to 3,000.
can't we just rent it from you? Yeah.
So this is a mortuary, not a rental house.
We're scattering the fucking ashes. But just because we're bereaved doesn't make us sad.
Sir, please lower your voices.
Man, don't you have, something else we can put them in,
That is our most modestly priced receptacle.
God damn it! Is there a Ralph's around here?
So here, your deal is poor Donnie's cremated body, and he's already at the mortuary. You've already got a deal. You've got to work something out. And the other side, as you can see, has some leverage here to insist on even the most modestly priced receptacle being somewhat expensive.
So in the movie, they go and they get a coffee can, and that's the way they resolve it. So look, we don't have that kind of solution. We don't have a coffee can. The takeaway here, though, is to really think about using post-closing adjustments sparingly, and then craft a process that's going to align with likely disputes. And so the things we're thinking about here is how to narrow subjectivity and uncertainty in these disputes, and how to really incentivize rational behavior. That's the control you have once you've decided that you're going to go this post-closing route. So look, the easy thing for us to say in a risk avoidance situation is like, never do this. Don't have post-closing adjustments. Don't have working capital adjustments. We recognize that that is too simple of a solution, not a practical one. These are market realities, and a lot of deals require them. A lot of parties want them. That's fine, and of course we accept that. But I also just would challenge you to think about whether every case literally requires one, because these things are not free. When you are agreeing to some sort of post-closing pricing adjustment, what you're doing is you're making a trade. You're trading finality on the one hand for some sort of ideal of certainty or precision on the back end that is difficult to achieve on the front end. That's fine, but that comes at a cost. And so you should go into the deal thinking about, okay, I've got this cost that I'm building into the deal through some sort of post-closing negotiation. Now, how do I think about what I'm likely to incur, and how do I minimize and cabin that cost? And so these are some considerations that we think you should be thinking about if you're going down a route of a deal that has anticipated a post-closing process. The first point is just that deals are run by human beings on both sides. You have to think about the temperament and the incentives of your counterparty. If you are a seller, will the buyer be holding money or needing to release an escrow as part of this purchase price adjustment? If you're a buyer, do you need your seller's cooperation, whether it is through information post-closing or ongoing litigation? Are these repeat players, or are they one-offs? All very important considerations when thinking about how likely it is you are to end up in a post-closing dispute. Many of the times when Jamie and I get called in by our clients or our deal lawyers on this, we are told these lawyers on the other side, they were horrible throughout the negotiation. They took all these unreasonable positions. They
don't know what market is.
They don't know what market is. Yeah, that's the one. They don't know what market is. Okay, well, that's a pretty good window of what they're going to be like post-closing. And the dynamic is different. Now you don't have the luxury of walking away from the table from that unreasonable counterparty. That's something to think about. Do you want to have a deal structured that's going to require you to be in a post-closing dispute with a counterparty that was hard to deal with on the front end before anybody was locked arms? What degree of ambiguity is there in your post-closing dispute? So obviously, the more subjective the future scenario, the greater the likelihood of the dispute. Ideally, any sort of post-closing trigger is tied to something that is as objective as possible. The patent was issued. The case got dismissed. Some sort of toggle that is easily verifiable in the reality-based world and isn't based on behavioral components or subjectivity. We talk about limiting the scope of the fact finder. There's all sorts of ways to do that. You can limit it in terms of subject matter. What are the categories of things that are open for debate post-closing? You can talk about it in terms of temporal limitations. What is the window by which these claims can be brought? And then you can talk about it in terms of amount and controversy. The easy one to think about is the ceiling, because we like to cabin risk for, say, indemnities and escrows with a high end. I think it's equally important to think about the low end. You don't want to have situations where the cost of the dispute exceed the amount in controversy, in which case there's extreme leverage to make it go away, which can be annoying. So I think it's useful to think about some sort of floor by which we're going to agree there's not going to be a dispute unless the dispute is more than, pick some threshold number, $5 million or something that makes it worth the effort to lawyer up and fight.
And just to explain the image on the right, I had a situation where this, unreasonable seller lawyer during the deal pops up afterward, and all his correspondence was sent on letterhead with this insane coat of arms on it. Not exactly that one, but same idea. So very concrete tip here is if your opposing lawyer has a coat of arms on his correspondence, there's probably going to be post-closing disputes.
So, we talked about the importance of identifying whether you have a rational counterparty or an irrational counterparty. Assuming that you have a rational counterparty, think about how do you set up your post-closing dispute so that you incentivize rational behavior. When we think about rationality in litigation, there's a pretty simple litigation math formula. The amount of the claim times the probability of winning minus the cost of suit equals the value of the claim. And the greater the value of the claim, the greater the likelihood that you're going to have litigation. You can control those toggles with the way you structure your deal and the way you structure your dispute resolution provisions. So what are some things that make a case more likely to litigate? Well, is the process expedited? If this is something that the parties think can be resolved quickly and easily, it's more likely to be litigated. Is there fee? Now, this is if you're a confident litigant, is there fee shifting? One downside to litigating is that it's just expensive to do. But if you feel really good about your claim and your contract will assign your litigation costs to the losing party, that's going to be an incentive to bring claims. Jamie talked about the mens rea element in the fraud piece. And then if there's a range of outcomes, if you can anchor with, I'm going to make a claim for $100 million, but I'm going to land somewhere in between 0 and 100 million, there's a greater likelihood that you'll bring a claim. Some toggles that make litigation less likely. If the party feels vulnerable to discovery burdens, if you are afraid of somebody looking underneath the hood or disrupting business by taking depositions, that's going to make people less likely to want to litigate. That's something you can control for in your dispute resolution process in terms of where you are and what the boundaries of discovery are. Fee shifting, the other side of fee shifting is it makes you less likely to litigate if you are less confident in your position. You're probably not going to take a flyer if you think that the cost of litigation, your opponent's cost of litigation, is going to be assigned to you. If the timelines are indefinite, if you don't have some sort of expedited process, many people are afraid of marching down a multi-year process. And then another tool that I think probably is not used enough is this: can you set up an all or nothing dynamic? So baseball arbitration eliminates this sort of weird anchoring incentive where a party is incented to claim $100 million of damage when in reality it's $5 million at most. Baseball arbitration creates a binary dynamic that makes the stakes a little bit higher and makes people be more rational as they approach litigation. The point is, all these things, all these toggles can be built into your dispute resolution process. It's not easy to say which of these you want, but context drives the consideration, and people like us can help you think through how best to do that.
And the one thing I'll add on baseball arbitration, there's all kinds of interesting scholarship on baseball arbitration. And one thing I didn't appreciate about it is one thing that baseball arbitration does is it leads to most of those disputes settling, because you're sort of narrowing the gap between the two parties. And then when you can see on paper, oh, okay, I'm at 4.8 million, they're at 5.2. What are we doing fighting? Let's, cut to the middle of it. So it's a really good way of forcing parties before you go all the way through the dispute to put their kind of best offer on the table, and then you can find a spot where you resolve it and you're not through the expense and disruption of continued litigation. Another thing that comes up a lot is accountant-driven dispute resolution, certainly something we see a lot. A lot of what we've been talking about on these prior slides is contemplating the accountant-driven arbitration as one feature here, one way you could do it. A common fight that happens when you have accountant arbitration is this really the kind of dispute that is supposed to be in front of the accountant? And so you'll get one party saying, yes, of course, it's the accountant's dispute, and somebody else saying, no, this should be in our other dispute resolution provision. And you're fighting about sort of like, what table are we sitting at, as opposed to, sitting there and fighting over it. The other thing that happens is you don't necessarily know that the accountant you end up with is going to be the right person to work this out. You could get Ben Affleck in the accountant, or you could get Kevin from The Office. And my point is just, arbitrators, professional arbitrators, or former judges, they're very experienced lawyers who are trained at not only, theoretically finding a fair outcome, but also kind of wrestling everybody to the table, getting the dispute heard in a way that feels fair to everybody, that has the right process. Even accountants that do this all the time, that's just not as much in their wheelhouse. I'll also add, you can get an arbitrator with accounting experience and go through regular arbitration, or you can get an arbitrator and both sides can present reports from accountants. You don't necessarily need the accountant to be the one deciding it. Another good thing on this is that a lot of these accountant arbitration provisions there's no appeal, there's no second look at anything. So you're putting a lot into the hands of one person who's going to decide this dispute.
There's probably some perspective bias here because when these come to me, they usually are pretty big disputes. I imagine there is a category of run-of-the-mill disputes where an accountant arbitrator is a fine resolution. But usually when they make their way to me, the stakes are high, the parties are fighting desperately about how to jockey and get the best outcome. Inevitably, one party doesn't want to be in front of an accountant arbitrator. And if both parties don't want to go in front of an accountant arbitrator, there are all sorts of tricks you can do to gum up that process and open another front in court. And I have seen it be a major distraction where we spent months, maybe even a year, fighting over where we're going to fight before we get the case resolved. So I'm not a fan of these provisions, but it's probably from the seat of like seeing things really go badly, more so than the run of the mill.
And we're going to wrap up talking about drag along rights, and I'll talk about what that is in a minute. But this is an area where we see this in a lot of contracts, especially in the private equity context. But there's very little litigation over the exercise of a drag right in the kind of way that most people today are exercising it. We have some experience fighting about the exercise of drag rights, and so can impart that experience that you won't necessarily see in sort of published case opinions. So what is a drag right? Returning to our friends at Meridian Forge, they purchased, let's say, an 80% interest in Clean Truck. The founder is still a minority owner in Clean Truck. And in the LLC agreement will be a provision that says Meridian Forge can sell 100% of Clean Truck to a third party and drag along the founder here, whether he likes it or not. And if you're structuring your drag right well, this happens automatically. Meridian Forge has a power of attorney and just signs a document on behalf of the founder that transfers these interests. Now, what I've heard from transactional lawyers and clients is that they don't like exercising this. They don't like doing it. If they can possibly get the founder to agree that this is a good deal, that's what they prefer to do. But it doesn't always work that way. The other feature here is much like, say, firing a key executive or buying a company that was just under an exclusivity agreement, this is an area where if you exercise a drag, just assume that the minority owner is paying someone like us to sit in a room and think about ways to disrupt this exercise because they don't like it. And so you've got to come at this very carefully when you exercise it and when you would put them into your contracts. You want to make sure it'll work in the real world in a way that doesn't undermine the benefit that you're paying for here. So some drafting considerations. And some of this is gleaned from case law, but like I said, most of the case law about drag rights comes up in the sort of corporation context where there are fiduciary duties you can't waive. And so you have to have like an investment committee that decides the deal is fair and that kind of thing not getting complied with. That's less common in the sort of private equity transactions we see where you have an LLC, you're waiving rights, and members can do things in their own interest and do a drag transaction. But the things you want to have in your provision, you want to have objective criteria, if any, for evaluating the deal. One that you see pretty commonly that seems fair is it has to be an arm's length transaction. And you know, if Meridian Forge is selling, they have to sell to an unrelated party so that there isn't sort of shenanigans there. But you want to define what arm's length means, you want to define what affiliate means, and you want to make it very objective and buttoned up so that the minority holder can't come in and say, this is an arm's length because one of your directors sits on a board that's adjacent to this other entity or something like that. You want to have clarity about fiduciary duties. That's always good advice. You want to reduce the number of steps required because the main way in the current world that minority owners can gum this up is just on sort of procedural technicalities. So the fewer procedural technicalities, the better. And you want to impose duties on the minority owner. The minority owner has a duty to cooperate when dragged. The minority owner has an obligation to do A, B, and C thing when a drag is exercised. And if they don't do it, you can sue the minority owner, you can get specific performance. Work that into your contract. And that's a way to protect yourself from the real world, which is you're making someone sell their company and they hate you for it. And then, okay, what about when you're executing the drag? As I flagged before, everyone's preference, and I get it, is to convince the minority owners that this is a good idea and that not have to execute the drag. The risk of doing that too much is you're creating a record of the merits of this deal and your process of this deal that could get brought up in litigation. You're also giving the minority owner time to try to gum this up by finding a court somewhere that will grant the minority owner a TRO to stop your deal. And if you go into some unsophisticated court who doesn't see a lot of this and you say to the judge, Judge, I founded this company with my blood, sweat, and tears. I own 40% of it, and private equity on the Hill is selling it right out from under me. That's the kind of thing you could imagine someone getting a TRO for a week or two and messing up your deal. So I kind of think you have to do a little bit of work on the front end to decide whether it's worth trying to bring along or just drag them and they get a letter that says, we sold your interest. Isn't this great? As I said before, you want to be very careful with the procedural requirements. If there are notice obligations for how you execute the drag and what you have to tell the minority owners, dot every I and cross every T. The one case I've found where in a private context, somebody gets screwed up, they didn't notice the drag in the right way, and the court said, no, we're going to hold you to that, and unwinds the transaction. But you also want to think about the physical assets that you're selling. We had an instance where drag gets executed. It's a beautiful V&E drafted drag provision. Everything moves over perfectly. Unfortunately, the minority owner has keys to the warehouse and he's not giving them up. So yes, we could sue him. He had an obligation to cooperate. We eventually got it sorted out. But you might want to do some work on the front end to just think through the practicalities of once you drag, what does the world look like and can your buyer get in? You also might want to, especially if you have obligations to the buyer in the long run, you might want to do some monitoring of your dragged minority owner to make sure that he or she's not going out there and starting a competing entity using your IP or something like that. Just think about somebody's mad, they're mad at you, they think you didn't do a good deal. How can they mess it up? That's one thing that you have to worry about. And then the other thing to think through is, what do you tell your buyer? I would say it's probably not good to, if you have some ongoing fight with your minority owner, to keep that from the buyer. Deal happens, and then you pop up and say, hey, we can't get into the warehouse. We didn't mention, by the way, that the founder of this company hates the deal and it's going to mess it up. So whether you have a legal obligation to or not, probably a good idea. If you're the buyer and you know something like this is going on, you might want to craft specific indemnities to address complications that could come from an uncooperative minority owner, and you might want certain representations dealing with that scenario.
That's it. That's the talk. We've got some faces here. Jamie and I are not the only people who deal with post-closing disputes. These are some of our colleagues around the firm who handle different flavors of this. Jeff Johnson here in Houston is a white collar and investigations specialist. Sometimes when you open up the hood, there's need for that. Across the top, Michael Holmes, Craig Zeminski, Meredith Lyons, they all really focus on Delaware dispute litigation. They all sit in Dallas. Nick Shum, bottom left, is an energy litigation expert. So I gave the example of the title to oil and gas wells and producing interest. That's his wheelhouse.
I think he prefers the title dirt lawyer, but
and then the bottom three are rep and warranty experts. So Sarah Mitchell is a partner in Dallas, Alex Eva and Mitchell Austin in Houston really focus on the sort of dispute side of rep and warranty insurance. There are many others, obviously, at V&E as well, in addition to me and Jamie, who do this kind of work. And that's it for our presentation. We're open for questions. We got one that came in over from somebody who's watching on Zoom, but I'll give deference to anybody who's in the room who's got a question, and then we'll go to that one. Okay, then over Zoom it is. So the question we got is there not more definition / higher obligation for best efforts under English law? I ask because English law governs most of my international agreements. I get to comfortably punt on this because I'm not an international arbitrator. So this is a jurisdictional specific question in terms of what best efforts requires. I've looked at it under Texas law. I've looked at it under Louisiana law. I've looked at it under New York law. And in all those jurisdictions, it is very squishy. I mean, it's kind of a some evidence standard of some effort to achieve whatever the obligation is under the contract. I found it is a very hard standard to prove that somebody breached, absent some sort of state of mind admission that you capture over email that they're acting in bad faith. They have no intention of moving the deal forward.
Yeah, I mean, we even had a case where the other side put on an expert witness, and the expert witness's opinion was, I look at these 5 things they did, and from that, as an expert, I conclude they were trying real hard. And, we tried to disqualify the expert. That's just kind of ridiculous. You're an expert on effort, but, it was arbitration, so they let him do it. But that's kind of all you have to do. You just have to show up and say, gosh, we really wanted to. And then, it's basically an illusory right you have at that point.
follow-up question we have is relatedly, do you see any disputes around obligations to act in good faith? Jamie, do you see that?
Yes, I mean, I would say language in a contract that gets at this sort of idea. You see best efforts, you see commercially reasonable efforts, commercial best efforts, and then sometimes you will see good faith. I mean, and depending on your jurisdiction, there might be an implicit good faith requirement to execute the contract. I think more common than, hey, you have to act in good faith is the sort of other examples we were just giving, because I think there's sort of the idea that, of course, you're going to perform the contract in good faith. But it's a good thing to flag, because not all jurisdictions are reading into the contract that everything you agree to do, you're going to do in good faith. So you could get yourself an independent cause of action if you contractually impose that obligation. I don't know if you think that's.
Yeah, and look, this is an area where that silly dynamic that we put up of pre-dispute dynamics and post-dispute, pre-closing dynamics and post-closing dynamics really come into play. It's a very common thing for a deal maker to say, I'm not talking to you about this. Absolutely no, this is a non-negotiable point. Pre-closing, that's a fine thing to do. Post-closing, when you're under a good faith obligation, putting that kind of thing in an email or saying that kind of thing at a meeting is pretty good evidence that you're not operating in good faith. I'm not going to talk to you about this. This is a non-starter. Go pound sand, which are things that deal makers say are not things you want to say in a post-closing environment. Again, now you're in a marriage, right? Like you don't have the ability to walk away. And so you got to at least play the game. And we have seen people kind of step in it by using that sort of tough negotiating language, which is common in a pre-closing concept, but not a good idea to use in a post-closing concept where you have good faith obligations.
That's a great point. The way I actually see that language the most is in a dispute resolution provision where like step 2 is executives from both companies have to meet in good faith and try to resolve it. And, I generally think those provisions don't accomplish a whole lot, but one thing it does is if you're in a dispute down the line, both sides are suddenly shooting at each other saying, they didn't negotiate in good faith because they only brought their regional vice president to the meeting. We brought our CFO, and it creates that kind of a dispute about what good faith means. But a lot like the best efforts language, the law on what good faith negotiation looks like, incredibly low bar to clear. Again, you just sort of have to show up at a meeting or two. But Chris is right that the things you say can cause problems for you and headaches in that category. Anything else? Well, that's good timing because it's 12:59. Thank you all for coming and really enjoyed doing it. And we'll hopefully be back soon with part 2 or something else to talk about. Thanks.